Okay guys, we are now in chapter 7, Extinguishment of Sale. Alright, let's proceed. Article 1600 provides that sales are extinguished as follows. So you have three common causes, you have your special and extra special. Okay, parang siopaw. Extra special siopaw. So common causes, those found in obligations and contracts. So in Article 1231 of the Civil Code, it provides that this is an obligation will be extinguished through the following means. So PLC3N. So that's P for payment or performance of the obligation, L for loss of the thing due, and then you have your C3s. Three C's rather, your three C's. So the first one is condonation, or pinapatawad ka na doon sa debt mo. Confusion or merger of rights. So naging isang tao yung debtor at saka yung creditor. Number 5 is yung compensation, meaning may utang ako sa iyo, may utang ka sa akin. Pagbangga na lang natin yung utang para ma-extinguish yung obligation natin sa isa't isa. Number 6 is novation. Ito yung parang ipapasa mo sa ibang tao yung obligation mo, or papalitan mo yung subject matter ng obligation. Okay, number 2, special law. These are found under sales law. And then number 3, yung extra special. This will be based on conventional or legal redemption. Okay? So, hindi na natin i-discuss itong 1231 kasi natalakay na yan sa oblicon So, dito tayo sa conventional or legal redemption. Okay? Teka. Let's check out the chapter 7 of the book. Okay, for purposes of this discussion, we just focus on the extra special extinguishment of sale. Okay? So, let's proceed. Conventional redemption. 1601, what is conventional redemption? This is the right which a vendor reserves to himself, the right to reacquire a property sold. So, ibig sabihin, si vendor or si seller, nagbenta siya ng isang property, pero meron siyang right na i-buy back or bilhin ulit, pabalik sa kanya yung pera. The same vendor must however reimburse the vendee of the price and expense of the sale. Both real and personal property may be subject of a conventional redemption. Okay, so it's very simple. Nagbenta yung vendor ng isang property, pwedeng real property, pwedeng personal property, and then later on, sabi niya, I want to buy back the property. 1602 talks about equitable mortgage, but before we go into that, let's have a refresher as to what a mortgage is. Okay, so a mortgage is a contract. A mortgage contract is an ancillary or security contract which is almost always, I think hindi lang almost always kundi always attached to a contract of loan. Here, the primary contract is the contract of loan, which includes the creditor and the debtor. It is ancillary. It is an ancillary contract because it is a contract that is related to the main contract but is subordinate to it. So, dito, ang mortgage contract, nakasabit yan doon sa contract of loan. So, ang primary parties ng contract of loan is yung creditor at yung debtor. Pinakamagandang example niyan is yung bangko. Yung bangko, nagpautang siya doon sa tao, sa isang tao. Halimbawa, ikaw na lang yung gagawin natin. Ikaw, kailangan mo ng 1 million kasi gusto mo magtayo ng negosyo, kaya someone in the family got sick, so you need money, di ba? So you took out a loan. Ngayon, kapag umutang ka sa bangko, ang mangyayari may utang ka ng 1 million. Yung bangko, siya ang creditor mo at ikaw yung debtor. You are debtor for the amount of 1 million. Ngayon, syempre, hindi naman papayag yung bangko na basta-basta na lang silang maglalabas ng 1M walang kasiguraduhan na mababayaran sila. Ang mga bangko, sigurista yan. Gusto nila mababayaran sila. So, hihingi sila sa iyo ng security. Okay? Ayan. So, dito. Now, the creditor, which is the bank, before parting with his money, would ask the debtor to provide him an item which has greater value, which is a value greater than the money he borrowed. Okay? Para sigurado na kapag hindi ka nagbayad, itong item na yung security na, yung item na binigay mo sa amin as security, yan ang ipambabayad namin sa utang mo. Okay, so yung item na to, ang tawag na ito is security. Security because it will secure the loan in case the debtor fails to pay his loan on the contract due date, to pay his loan contract on due date. The debtor then mortgages the property to the creditor. So yun yung act para ma-formalize yung security. Okay, so yung debtor, which is ikaw, kailangan mo ng pera pero wala kang pera eh. Pero may mga assets ka. Halimbawa, may bahay ka sa Tagaytay. Okay, so yun yung imo-mortgage mo. Ibig sabihin, susurrender mo yung original title ng property sa bangko, tapos yung bangko tatatakan doon ng annotation dun sa likod. Nakalagay doon, Mr. Ganito owes the bank 1 million and as security, he attached this property, or this property is mortgaged to the bank for that amount of money. Okay? In their status will now be changed from debtor, mortgagor. So, since ikaw yung debtor, pero ikaw yung may-ari na property at minomortgage mo yung property, ang tawag sa'yo ay mortgagor then at the same time. So, you are both the debtor and the mortgagor. Okay? Yung bangko naman, he is both the creditor and mortgagee. Okay? In the event that the debtor fails to pay on due date, the creditor may institute this proceeding called a foreclosure proceeding so that the court may acquire the security. The court may acquire the security and sell the same in the public auction, the proceeds of which will now be used to pay the creditor. Yan. So that's how it works. Kaya yung bangko, yung mayaman. Kasi, imagine mo kung may nangutang ng 1 million tapos nagsangala ng 1.5 million, di ba? Tapos, hindi nakapagbayad ng 1M. Ang ginawa ng bank, finorclose yung property na worth 1.5 and then binenta sa public auction. Siyempre, dun hindi siya public auction eh. Ay, pwede palang public auction. Pwede ding private auction. Binenta dun sa auction at hindi 1.5 pero siguro 1.2. Tapos usually ang bumibili din dun yung bangko eh. E di kumita yung bangko. 'Di ba? So now we remember what a mortgage is. Now we ask, what's an equitable mortgage? Okay, an equitable mortgage is one which lacks the formalities of a mortgage, but the agreement shows the intention of the parties to make the property subject of a contract as a security for the fulfillment of obligation. Okay? So, here, there is no sale. What happened was merely a loan with security. Okay? Ngayon, baka magtatanong ka, ano ba yung equitable mortgage na yan? Ang ibig sabihin lang yan, hindi nyo nilagay sa papel na ito ay mortgage. Pero the law will interpret it as a mortgage for the safety of the debtor / mortgagor. Okay? An equitable mortgage is one which the lender is secured by taking possession of all the original title documents of the property that serves as security for the mortgage. It gives the mortgagee the right to foreclose on the property, sell it, or appoint a receiver in case of non-payment. So, what are the instances when the law presumes that there is an equitable mortgage? Okay, Article 1602 provides that the contract shall be presumed to be an equitable mortgage in the following cases. So, ulitin ko, dito sa situation na to, ang nakalagay dun sa property is a deed of sale siya with a right to repurchase. Okay, yun yung nakalagay dun sa property. Deed of sale with a right to repurchase. Okay? Pero the law will interpret it as a loan with a mortgage. Otherwise, equitable mortgage. Okay? So, mag-a-apply ito kapag yung deed of sale mo ay mababa yung presyo. The price of the sale with the right to repurchase is usually inadequate. Okay? Hindi siya deed of sale. In reality, hindi talaga siya deed of sale. Okay? Hindi ko alam kung nasusundan ninyo kasi medyo sa totoo lang dati na sobrang nahirapan din ako i-grasp yung concept na ito. Pero I will try to explain my best, ha. Ganito kasi yan. Nag-uusap tayo dito sa topic ng conventional redemption. Okay? Ang conventional redemption is simply a sale with a right to repurchase. Okay? So si A, binenta niya yung property niya kay B, tapos may stipulation doon na pwede niyang i-buy back yung property. Okay? Within, sabihin natin, after 6 months, or after 3 months, or after 1 year, may karapatan siyang bilhin yung property. Ang conventional redemption, that is a perfectly valid contract. Okay? Pero ito ay inaabuso. Tinitake advantage ito ng ibang tao. Bakit? Kasi, yung iba, halimbawa ay nagpapautang sila, tapos they want security. Ang nangyayari ngayon, pinautang nila yung tao, pero kailangan nila ng security, di ba? So, dadaan ka dun sa process ng mortgage, right? Ng loan, contract of loan with mortgage. So, sabihin natin hindi ka sa bangko umutang, kundi sa private individual. Kung sa private individual ka, ganyan din halos ang proseso. Pero pwedeng mas magulang yung private individual kasi hindi siya masisilip ng banking laws kaya pwede niyang manipulahin yung kontrata. Paano mamanipulahin? So ganito, usually nangyayari ito sa mga sugalan di ba? Lalong-lalo na yung mga nalululong sa sugal, sa mga soler, sa mga big casinos. Ang gagawin nila, uutang sila ng pera. Ngayon, pag umutang sila, dapat kasi ang document mo dyan is contract of loan, di ba? Tapos, as security, meron kang secondary contract na mortgage. Dapat ganon. Pero, ang ginagawa ng mga lender, iibahin nila yung kontrata. Ang gagawin nilang deed of sale with right of repurchase. Parang ganon din yung epekto doon sa it can be very similar to a contract of loan with mortgage, but the effect is different. Why? Kasi dito, ang gagawin nila, babalik tayo dun sa example, ha. Sabihin natin, may tao na gustong mangutang ng 1M. Okay? So, normally, ang mangyayari niyan, contract of loan ka muna. Pagkatapos nun, sabihin natin, gagawin mong security yung yung lupa mo na worth 2 million sa Antipolo. Okay, so yan niya yung yung mortgage mo, naka-mortgage siya ka. So, ang nangyari is contract of loan with mortgage. Pag hindi mo yan nabayaran, automatically ba mapupunta? Ito kasi yung kinon Kapag, ito yung pinagkaiba nila. Kapag, at saka, mas maiintindihan niyo kung bakit maraming umaabuso dito. Kasi, kapag loan yan, tapos, may mortgage contract na naka-attach, kapag hindi nabayaran yung loan, magi-institute pa ng foreclosure proceeding sa korte yung lender. So, magastos at matagal. Diba? At, hindi pa mapupunta sa kanya yung property na yon kasi ibibidding yon sa auction. So, may possibility na ibang tao pa yung makakuha nun. Whereas, kung mautak ka at alam mong batas, iibahin mo ang wording. Ang gagawin mo, instead of loan for 1 million, ang gagawin mo, deed of sale of property for 1 million. Tapos yung naka-secured na 2 million pesos na property na dapat naka-mortgage, yun yung gagawing subject matter mo doon sa deed of sale. Okay? Ngayon, nasusundan mo ba so far? So, dun sa unang example natin, ito yung legal yung legal, which is loan with mortgage. Naka-mortgage ka ng 2 million peso property pero umutang ka lang ng 1 million. Okay? So, dalawa yung kontrata mo dun sa unang example, which is loan for 1 million and then mortgage. You mortgage your 2 million peso property. Whereas, on the other hand, ang gagawin nung nagpapautang sa'yo, ito na lang pirmahan mo. Deed of sale with right of repurchase. Pareho lang naman yan. Okay? May oras ka pa rin naman para bayaran yung utang mo. Okay? Pero naisahan ka na pala. Bakit? Kasi ang mangyayari dyan, kung ang ginawa niya is deed of sale, tapos ang ilalagay niya na presyo dun sa deed of sale is yung utang mo na 1 million pesos. Tapos, yung security na lupa na worth 2 million, yun yung ginawa niyang subject matter ng deed of sale with right to repurchase. Tapos sabihin natin na dun sa unang kontrata, meron kang 6 months upang bayaran yung yung utang mo. Gagawin niya dito, meron kang 6 months na period para i-redeem yung property mo. Ngayon, kung hindi ka nakapagbayad ng 6 months dun sa unang senaryo, ang mangyayari, i-foreclose yung property. Whereas, dito sa pangalawang example, if after 6 months hindi mo nabayaran, consolidated na yung ownership ng property doon sa lender. So, ang nangyari ngayon, yung property na yan, wala nang bidding, wala nang auction. Automatic, naging pag-aari na yan ng lender. Diba? Nasusundan nyo ba? Ngayon ang tanong is, legal ba to or hindi? Ang sagot is, hindi to legal. Kasi kung titingnan mo dun sa sa civil code natin, ang tawag dyan is pactum commercium That is illegal. Yung automatic transfer of ownership to the lender or to the mortgagee, automatic transfer to the mortgagee. That is illegal. Kasi it's usually used by rich people to take advantage of the poor people who desperately need money. Okay? Which is the case naman talaga, di ba? But you see the relevance of knowing the law. Grabe yung effect no? Kung dito sa una, it's loan with contract of mortgage, pag nagbidding yan, pwede pang ibalik sa'yo yung balanse. Dun sa kabila, ng deed of sale with right to repurchase, matic transfer agad. Diba? Transfer dun sa lender mo. Whereas dun sa isa, dun sa nauna, ibibenta pa yan sa auction. Okay. Hi, I tried my best to explain it. I hope you were able to follow that. Okay, so here the law says, Article 1602 provides that the contract shall be presumed to be an equitable mortgage in any of the following cases. So ang presumption is equitable mortgage siya even though it is denominated or entitled as sale with the right of rescission. Number 1, when the price of the sale is with the right to repurchase is unusually inadequate. Inadequate nga naman talaga. Kung 2 million yung property, 1 million lang binenta, inadequate yan. Okay? So, isa yan sa mga red flag or indicators na ang intention talaga ng parties is utang and mortgage. Hindi benta at bibilin uli. Okay? Number 2, when the vendor remains in possession as lessee or otherwise. So, yung nagbenta, siya pa rin yung nakatira dun sa property. So, ang intention niya talaga, hindi niya talaga intention na ibenta, kundi mangutang lang at gawing security yung kanyang property. Number 3, when upon or after the expiration of the right to repurchase, another instrument extending the period of redemption or granting a new period is executed. So, isa pa yung indicator na talagang mortgage yung utang at mortgage, kasi sasabihin mo, sige na please, pahingi pa ng extension kahit 1 month lang para mabayaran ko yung utang. So, nagawa sila ng isa pang kontrata to extend the redemption period. Number 4, when the buyer retains for himself the part of the purchase price. The buyer retains for himself part of the purchase price. So, sino nga uli ang buyer dito? Well, ang magiging buyer dito is yung yung nagpautang di ba? Siya yung lender talaga pero magiging lender buyer siya. So, he retains a part of the purchase price. Number 5, the seller binds himself to pay the taxes on the things sold. So, kung siya yung nagbenta at intention niya talaga na ibenta yun, bakit babayaran yung tax? Ang totoo niyan, nag-utang lang talaga siya. At gusto niya lang gamiting security yung bahay niya. In any other case where it may be fairly inferred that the real intention of the parties is that the transaction shall secure the payment of a debt or performance of an obligation. See, that's really the purpose. But other people, they take advantage of this particular hole in the law. Or may kasi ito, may butas And kung makapitalize mo ito, posibleng yumaman ka talaga. Diba? In the above-mentioned examples, although the parties call their arrangement a pacto de retro sale, a pacto de retro is a sale with a right to repurchase, or a sale with a right to repurchase, what they really intended was a loan agreement with a security. Okay, and that security is what you call a mortgage, diba? So, yung intention talaga nila is loan agreement with mortgage. Pero, ang nilagay nila sa papel, pacto de retro sale. So, what happened is the money loan is made to appear as the purchase price, kagaya ng in-explain ko kanina, and the period to pay the loan is called the redemption period. If the debtor does not repay the loan, the property will be forfeited in favor of the creditor buyer. Okay? So what's a pacto de retro sale? A sale with pacto de retro transfers the legal title to the vendee ay retro. The essence of a pacto de retro sale is that the title and ownership of the property sold are immediately vested in the buyer, subject to the resolutory condition of the purchase by the seller to repurchase the property within number 1, the period agreed upon, or in the absence thereof as provided by law. So, sa pacto de retro sale, yung ownership ng property automatic nagta-transfer doon sa buyer. Tapos, meron lang period of time para i-buy back ng seller ng seller yung property para makuha niya. Kung hindi niya ma-buy back yun, consolidated na yan. Ito may mga na-handle ako na kaso na ganito before in the past. In case of doubt, a contract purporting to be a sale with a right to repurchase or a pacto de retro sale shall be construed as an equitable mortgage. Okay, so for instance, S sells his condo to B for 1 million. The value of the property is really 1 million, but both B and S agree that that S may reacquire the property within 1 year of the sale. So this is what you call a valid pacto de retro sale or a sale with the right to repurchase. Okay, pupunta naman tayo dun sa second scenario. Ito, yung nakalagay dun sa sale is pacto de retro sale, pero ang interpretation ng law dito is equitable mortgage. So the seller sells his condo to B for 200,000 pesos. But the value of the property is really 1 million. But both B and S agreed. So, sandali lang ha. The value of the property is really 1 million, pero ang nakalagay dun sa pacto de retro sale or sale with the right to repurchase, ang value is 200,000 pesos lang. So, yan yung unang red flag, diba? Indicator yan na ang intention talaga ng parties is utang ito at hindi ito pagbibenta. Okay? So, the value of the property is really 1 million, but both B and S agree that S may reacquire the property within 1 year of the sale for 200,000. So, ibig sabihin, sabi sa kanya nung nagpapautang sa kanya, sige na mare, basta bayaran mo na lang ito after 1 year, tapos okay na, babalik ko na sa yung property. Okay, so, dito, this is an example of an equitable mortgage since the intention of the parties is really a loan. Utang talaga. Tapos may security lang, which is yung condo. Hindi niya talaga intention na ibibenta niya yung condo. So even if the parties name their contract as sale with the right to repurchase or a pacto de retro sale, in reality, this is an equitable mortgage. Okay, very, very important to. I hope you remember this as you grow old. Okay, if you want to abuse it, you can earn a lot of money. But more than that, you know how not to be deceived by these types of contract because they are more common than you think. Okay, and I hope that you do not take advantage of other people also by knowing this particular provision of the law. 1616. The vendor cannot avail himself of the right to repurchase without returning to the vendee, number 1, the price of the sale, number 2, expense of the contract, and then number 3, necessary and useful expenses. Okay, so hindi mo pwedeng bilhin yung property kung hindi mo naman nabayaran yung price of sale. Tapos yung expenses, yung sa kontrata, kagaya ng mga capital gains, etc. na binabayaran. 1619 talks about legal redemption. Legal redemption is the right to be subrogated or to be transferred in place of one who acquires a thing by purchase or the shown in payment or by any other transaction whereby ownership is transmitted by onerous title. Okay, so yung una, yung conventional redemption, agreement of the parties. Ito, legal redemption as provided to by law. There is the shown in payment when property alienated to the creditor in satisfaction of a debt in money. Legal redemption arises from law. Conventional redemption arises from agreement of the parties. So, important yan ha. Legal redemption arises from law, meaning by operation of law. Yung conventional redemption, yung parties nag-agree na pwedeng bilhin niya uli. Okay? So, babalik tayo. Legal redemption is the right to be subrogated or to be transferred in the place of one who acquires a thing by purchase or addition in payment or by another whereby ownership is transmitted by onerous title. Okay, so 1620, the right of legal redemption of co-owner. So there must be requisites. Number 1, there must be co-ownership. Number 2, there must be alienation of all or of the shares of the co-owner. Number 3, the sale must be to a stranger. And then number 4, there must be partition. Okay, so medyo, again, you don't really normally encounter this in practice kasi medyo niche practice ito eh. Example, si XYZ, they are co-owners of a parcel of land. Then si X, binenta niya kay third person or kay letter B yung kanyang share for 20,000 pesos. Okay, so here, si Y at saka si Z, they may exercise the right of redemption by reimbursing B, the price. So, yung third party, kailangan niyang ibigay yung property na binenta sa kanya. Okay? So, legal redemption yan of a co-owner. Alright? So, that's where we end extinguishment of sale.